During the webinar, y'all, this is a very interactive session, so please feel free, interact, share some Q&As, some questions that you have. And if you're having technical issues, please just send me a note. Really happy to help, in whatever way I can. After the webinar, we are going to be sending out a recording. So rest assured, if you guys aren't able to get the questions or you're able to take notes, you can go back and rewatch. And then a survey is going to launch. But I do want to cover one quick thing real fast. I want to make sure I cover this disclaimer here. This presentation provides information of a general nature. None of the information here is intended as legal advice or opinion relative to specific matters, facts, situations, or issues. You should consult with a lawyer and legal counsel about your particular circumstance before acting on any of this information, because it may not be applicable to your situation. So that said, I want to hand things over to Lachie. And Lachie, go ahead and kick us off.
Thank you so much, Ryan. Welcome, everyone. We're happy to be here with you. We have an exciting conversation related to the recent H-1B changes, and we'd like to discuss how those are impacting business. What does it all mean? What are some solutions that we can suggest? And what are some of the opportunities on the global side as well of talent management? So what I would like to do now is introduce you to our esteemed panel of speakers. Ryan, we can go ahead and go to the next slide if you don't mind. What we'll be discussing today will be the new landscape, some of the updates that we're seeing, where do we stand today. Of course, we would like to invite you to participate in a live Q&A session. This was meant to be a very engaging type of webinar, so we invite your emojis, comments, questions. Please drop them in the Q&A or in the chat, and we're happy to have a very engaging conversation. So without further ado, we can go ahead and kick this off with some intros. Welcome, everyone. My name is Lachie Delchev. I'm the Strategic Director here at Mitratech for our immigration case management platforms. We are honored to work with more than 1,500 organizations in this space. And I would like to give an opportunity to our wonderful speakers to say hello to you. Linda, do you mind if we start with you, and then over to Lisa and Jonathan?
Hi, I'm Linda Kim. I'm a partner with Vakori Global Immigration. I've been practicing business immigration for over 26 years. I'm here in the Bay Area in San Francisco. I actually started working at an immigration law firm here that helped my wonderful immigrant parents come to the US. I enjoy working with corporations. I worked in-house for 5 years. So I feel like I have a solid, a sense of what business needs as well as the legal. One of my main premises as we've been going through all of these H-1B changes, I've been reading scripture. Psalm 119 says, "Open my eyes to see the wonderful things in your law." And I really try to use that as a premise for my spiritual life as well as just my work ethics.
Wonderful. Thank you, Kim. Lisa?
Hi, I'm Lisa Atkins, and I'm a partner at Clark Hill. I'm based also in the San Francisco Bay Area. I've been practicing corporate immigration law for almost 2 decades now. My practice area focuses both on inbound U.S. immigration and also on outbound global immigration. I have a team that is based in APAC and also EMEA as well as the Americas. And we centrally coordinate outbound global mobility assignments, mainly for corporations, but also for individuals as well. I've worked at a number of boutique and large global immigration firms. And prior to joining a corporate immigration practice, I actually was involved in policy and worked at the Chamber of Commerce in DC and also the Department of Homeland Security, and actually worked on immigration reform issues regarding US immigration reform. So well, there's a lot going on right now with this administration. There's also, a lot of exciting things and exciting changes that, really show how kind of the courts, the regulatory environment, and also the executive branch all interact and how they all really impact the field of immigration.
Wonderful. Thank you, Lisa. Jonathan?
Hi, my name's Jonathan Grode. I'm the managing partner for Green and Spiegel's U.S. offices. We have offices in Canada and the United States, providing North American solutions for business immigration. I really like what my colleagues are saying about how they got into it and the experience, and we all have a pathway to professionalism. Mine starts just purely from a love of travel and understanding culture, and I turned what was a heavy emphasis, excuse me, on international travel when I was in my 20s to a career where I get to say I get to travel without leaving my desk. Because as all of us know, we talk to people from all over the world every day. And I share Lisa's sentiment that whilst it's challenging right now, and certainly we are constantly being bombarded with new and different rules and policies and procedures to get our head around, pragmatism, planning, pushing back on laws that don't make sense through legal actions, whether it be the Chamber of Commerce or individual states, are the ways that we all will be able to continue what we do. So I'm excited to be a panelist here and to kind of unpack a little of that same stuff when it comes to the H-1B.
Wonderful. Thank you, Jonathan. So if you don't mind, we'll actually go ahead and kick off the conversation with you. I'm personally just returning from the Worldwide DRC conference where one of the corporate panelists, it was actually Denise Rahmani from Oracle, mentioned that if she could summarize the situation for all of us right now, it is buckle up, buttercup, which in a way became the quote of the conference. And I think we can all relate to it working in this industry. But can you tell us a little bit about what are you currently hearing from corporate clients in terms of their current issues that they're worried about? How are they responding to some of the changes? Can you see any themes in the sort of frontline conversation?
Well, I think, fundamentally, we have to appreciate the fact that businesses crave predictability. We want some modicum of certainty. And one of the hallmarks of the US legal system is that there is this sense of certainty. And
Yeah.
what this administration's playbook has been as it relates to law in general, if it was 20 years from now, Lachi, and I was looking back, I'd find this incredibly fascinating. But we actually have a new way of governing, even different from the first Trump administration. We saw hints of it before, but it's on full bore right now, which is rather than taking a scalpel to something and changing it slightly to adhere to your policy, we're just going to blow it up. We're just going to destroy the entire thing and let the courts pull it back together, or let public opinion force us to modify our policy. And what's interesting about that is it is the most effective way I've ever seen of changing behavior. Because it's what grabs the headlines, it's what's getting everybody's attention that's causing an outroar and an uproar in the press and causing us immigration practitioners to spend Friday into Sunday triaging emails and playing therapist. But they don't, I think, personally care so much about the law, and they care more about the effect. So just to give an example before we move on, when there was this existential crisis with Harvard in the spring, and the administration comes out and says, we're canceling all student visas issued by Harvard University. That ripped across headlines internationally as well as nationally. And although Harvard had an injunctive brief filed the next day that was immediately approved, that doesn't get the same attention.
Yeah.
It doesn't get the same recognition. And what do we see? Student enrollment is down by 20% by international students nationwide for this semester. So does the Trump administration really want to have something like $100,000 fee? I don't know, but I don't think they care. I think what they care about more is how it affects the usage of the program. And you're starting to see this. Some outsourcing companies are saying that they're not going to use the H-1B. I personally have clients that have come to me and said, it just ain't worth it anymore.
Mm-hmm.
Now, for those that are left behind, and we talk about silver linings, it has a corollary benefit of probably an enhanced chance of being selected in the lottery. So
Yeah.
it is a fascinating scenario. And you know when they're serious because that's when they're putting in regulatory changes, where they're actually engaging in notice and comment or attempting to. And that's when I think when we start talking about the changes to the wage levels as it relates to the lottery later in this panel, you're going to see some actual insights that we need to be very mindful of. So that's kind of the lay of the land in terms of what's being said and how people are reacting and where the concerns are.
And then I also want to add that, I mean, I agree with everything that Jonathan said, but also we are, I mean, just today there was a headline of October has some of the largest layoffs and job cuts in corporate America that we've seen in over 20 years. And so, you know, with the H-1B in particular, and with corporate lawyers and corporate immigration lawyers in particular, I always tell people that a lot of our business cycle has to do with the hiring cycle, right? Because if we're working with a corporate client and maybe out of 5 or 1 out of 10 people is an immigrant and has a visa and needs assistance, that's, you know, then we step in and jump in. And so if a corporation is not hiring and they're laying off and kind of constricting their labor force, that automatically has an impact on our business, especially in certain industries like tech, for example, where out in, you know, the Bay Area, I service a lot of tech clients. And so even, you know, before all of these changes in economic downturns or periods of high layoffs, we would see a constriction in our business just in terms of less H-1B change of employers, less overall H-1B cap filings, because people aren't hiring as much. And so I think we have that factor, which isn't, I mean, is somewhat unrelated because it's, you know, the overall job market and labor market in the United States and kind of corporate clients and reliance on AI and all these other things kind of impacting that with some of these, the proclamation and some of these other things. I like to call them throwing a bunch of spaghetti at a wall and seeing what sticks. So it has an even more chilling effect, I think, on corporations because they're already laying off and reducing their labor force. And so why are they then going to go jump through these hoops to hire foreign workers? And so I think it's an even, you know, more constricted funnel in some ways. And it's just becoming more exacerbated in my conversations with corporations in terms of what their immigration strategy is and kind of how much they're willing to spend on immigration, and you know, put in time and effort on immigration moving forward.
And Lisa, and not to get too far ahead of ourselves, but I think that you actually hit on a very fascinating point because it's very like sector and industry driven. And I know you and Linda are both in the Bay Area, which is like heavy into that tech aspect of it, where you're seeing technology kind of affecting the labor market. A lot of my clients are on the engineering and manufacturing side, and that demand hasn't changed because
And coming back.
it's coming back, and it's a very fascinating thing. And this is where I find fault with the administration on having actually a decent idea or something that needs to be addressed, but attacking it in a very odd way. So when we talk about that $100,000 thing that like hang over all of us, if you read the preamble, it was like you can't have a company laying off 15,000 people and then in the same breath filing for 5,000 H-1Bs. Like it doesn't jive.
Yeah.
But they use that for the justification for getting rid of every H-1B, unless you got $100,000 for me, in which case it's okay. Now, we've talked about this before, but with perm, we have a rule that says if you've had a layoff in the area of intended employment, you're not allowed to do perm for a period of time.
Right.
I would have rather of them gone to the Congress where they have the House and the Senate and said, you know, let's have a similar rule put into place for H-1Bs to curtail this situation. And I think most everybody would be on board with that conceptually.
Mm.
And this is what I mean about the administration, what they're trying to do. So I think you actually highlighted like a great example.
Yeah.
Yeah. Well, I also feel like there's just a strong sense of enforcement that they're putting fear out there, right? If you follow like USCIS on LinkedIn, you'll see like they comment on every criminal that they've deported. And it's like, it's so strong. It's put such a fear in our corporate clients too. Just like, how do they approach? I tell people, don't go on social media, don't protest, don't do things that are going to put your journey here, the immigration journey here, into jeopardy. And I've just never had to tell someone that before. Like there's just that freedom of speech, but is it really there anymore? And I just feel like it's all about enforcement.
Yeah.
Well, today the headline came out that the administration has revoked over 80,000 non-immigrant visas since the beginning of this year.
Yeah.
So, I mean, obviously a large portion of them are for like, low-hanging criminal offenses. So DUIs, assault, theft, I think that was like maybe 30 to 40%. But then the rest are student visas. There was some free speech, some of those, free speech aspects that you were talking about. But it's, that's the goal essentially, right? Is that that's the
Yeah.
enforcement piece.
Yeah.
So that all resonates with some of the comments and conversations we also had at the Worldwide ERC conference. One of the things that I found interesting, and this was shared across many of the sessions, on which the corporate leaders spoke, is that they now have a much more important seat on the table when it comes to visibility of immigration compliance and talent strategy at the C level compared to what they've had in the past, which in a way is silver lining, in my opinion, because that hasn't always been the case, right? It can, global mobility and immigration compliance can be one of those things that people only care about it if it's a problem, right? So it seems like that has significantly changed as a result of some of these H-1B program updates, let's say. Let's go ahead and dive into some of the updates. Let's talk about the $100,000 fee in particular. Linda, if you don't mind, I'll ask you to comment on this one for us. Can you tell us, since middle of September, when this was initially announced, can you just give us a quick summary of what happened and where are we with this as things stand today?
Sure. So yes, on September 19th, our day of infamy for our 35-year-old H-1B visa program, the president issued a H-1B proclamation. Section 1 is the one that discusses the $100,000 fee, and it's about entry in a specialty occupation and petitions. So if you watch the video, I watched the video of the signing of the proclamation. I found that very interesting. Both the president and the commerce secretary make comments that every company is on board, including big tech, and that this is going to generate hundreds of millions of dollars. There was a question from the audience about big tech and discussing this with CEOs. And the president's statement is that everyone is going to be happy. They are really happy. So if you look at some of the verbiage too in the proclamation, it talks about abuse and deporting families, and there's just, it's all over the place. So there was major pushback from that announcement on September 19th. The Saturday following, you have USCIS, CPB, and the White House secretary trying to explain what the proclamation was referring to. Finally, we have some clarification on October 20th, where they're stating that the $100,000 fee only applies to those outside the U.S. who do not have a valid H-1B visa. It doesn't apply to those here that are filing amendments, extensions, or if you already have an H-1B, you can go abroad and get your visa stamped and come back in. So that saved our F1 students so that, any change of status, it doesn't apply to them. And currently the fee is effective. They provided payment instructions through pay.gov. We've got a few of those. and it's sent out as a NOID, a notice of intent to deny. You have 30 days, 33 if you received it in the mail, to come up with your $100,000 to, get your candidate here into the U.S. So that's where it sits right now.
Thank you so much. I found it interesting at the conference that some employers are in a way happy about it, right? Because they're like, we're happy to pay. And this gives us an advantage over attracting talent, etc. So they're fine with it. But of course, that's not the case across the board. Lisa, would you like to comment on this a little bit as to how are some of your corporate clients reacting?
Yeah, so it's interesting. At Clark Hill, we have a lot of different immigration practices. So we have a corporate practice, we have a global immigration outbound practice, we have defense, we have removal, I-9 compliance, and then we also have a very large medical practice with J1s, Conrad 30 petitions. And so one of my colleagues actually has a doctor who was US trained, did his residency here, and had to travel home for a family emergency. And unfortunately is going to be working at a nonprofit hospital, university affiliated in the US, has a job, is very talented in a rural area, actually, and is stuck outside subject to this $100,000 fee. And, for a nonprofit hospital, it's not feasible to pay this, especially for every single doctor that they need to come in. And so we submitted, to the, website or to the email address that they provided at USCIS, a request for an exemption. However, the language in the proclamation is very, very narrow. It's much more narrow than it was during COVID, where we had travel ban exemptions in the national interest. I don't know if people remember that in 2020, where if you were in certain industries, you could get in and get an exemption from the travel ban, or if you proved that you had certain value to the economy, et cetera. And so with this, the language is like, it's essentially extraordinary. And so no one really understands what it takes to get this exemption.
Well, I mean, let's be real. I don't even think they know.
Exactly. Well, that's correct. And so everyone is just kind of submitting blindly. Like we're submitting paperwork, the residency, like showing the rural hospital. Yet there's no real deadline for when they have to reply. So what we're finding is like, cases that where we paid the premium processing fee for a 15-day turnaround. They're not, usually with when you pay for premium processing with an RFE response or even a NOID response, you'll generally hear back within that amount of time. However, for this exemption, like Jonathan said, I don't think they know what they're doing.
Well,
so,
and just to kind of add that, Lisa, like, I don't even think they were aware of the unintended consequences of this particular provision, because it came from Commerce, not from DHS. This was announced on the heels of this gold card thing, which we'll save for another webinar another day. But it was announced by, they didn't even talk to the agencies before the announcement. There was no coordination with CBP. There was no coordination with state. Everybody's finding out at the same time. It's like your favorite baseball player being traded and finding out about it in a tweet because the GM didn't bother to call him. I mean, the level of, and then they get on and they have their own webinar about it, and they're saying, well, why are you guys so up in arms about this thing? It doesn't even kick in until the next cap lottery. And everybody's like, what about the doctors?
Exactly. And researchers and
exactly. I think what's interesting here on the legal perspective is that the court challenges that have been brought through specifically by the Chamber of Commerce, and I really applaud the chamber here. They moved for they moved for an injunction or a summary judgment. The judge found that the summary judgment had so much weight to it that they accelerated the briefing schedule on it. So rather than even go for an injunction, they're looking to the legality of the law itself, which I think all of us will say, to be kind, that it is on tenuous grounds at best. So, but Lisa, this goes back to what we opened with, is like this unpredictability, this inability to know what is coming down the pike is affecting behavior of employers. It's
Yeah.
changing the way they're looking at these programs. And when it's something that we can all agree on is like a heavy need in the country, like medical care professionals,
Especially in rural areas, like.
especially in the community
Got it.
hospitals
Yeah.
and those, it is particularly detrimental. So
Yeah.
Yeah.
Well,
it's
I think the
Go for
Chamber
it.
of Commerce filing that lawsuit, I mean, they were a longtime supporter of Trump too. And they came out, and then the AAU joined them, right? And yes, that judge, the Honorable Senior Judge Beryl A. Howell, raised it up for her because she comes out and slams that and says, you got to respond. They denied their request to, extend the briefing. And I think the government said that they didn't have time because of the government shutdown. And I was
Yeah.
like, hey, even we have to prove some like extraordinary circumstances for our H-1Bs to get some type of extension, right? Or so I found it all pretty fascinating in the briefing too.
And Linda, just a quick question that maybe people are wondering about. What is the rough estimate, let's say, that we can foresee in terms of the outcome of some of these cases that have been filed against the H-1B fee?
So right now, the Chamber and AAU case before the district judge in DC, they have to respond to the opposition to summary judgment by November 28th.
Okay.
And then the Chamber and AAU are allowed to file a reply by December 8th, 2025. And then the judge is going to decide if she'll hear the oral arguments. But we don't think that's going to be necessary. And I believe that they're likely to issue a decision before the end of December.
I concur. Actually,
Yeah.
that was like
Yeah.
really well laid out, Linda. But
Right?
that's exactly where I have it too. That's my peg on it.
Now there is an appeal process, right? So they have the right to appeal, but we don't know if the district court is going to allow the proclamation to stay in effect or allow the proclamation to be blocked, right? So, and that final decision could take up to a year.
My feeling is if they move for summary judgment, they're going to keep it blocked on appeal. But that's just my best guess. I think it's more likely we'll see a $10,000 or $100,000 like V2, like we saw with the travel bans in 2017.
Right.
They kept trying to hit it.
Yeah.
Or they might say, you know what, we've changed enough of the behavior here. Let's go attack something else, because that's the big difference between this time around and the first administration. Like they were almost singularly focused on this travel ban. Now we're getting hit on every single side, and every single angle,
every side.
They're just.
And I mean, I think like, people start planning for the H-1B cap now, right? Large companies start planning in November. I mean, some of them have already been planning for months, but November, December, some smaller businesses will look at it in January. So, if it's still in effect today and we're at November 6th, that behavior has already changed, right?
That's the point, right?
Budget planning, we're at the end of Q4 for most companies that are on, just the calendar year. And so all of those things like budget planning, kind of resource allocation, staffing, all of those decisions are being made or have been made within the last quarter or this quarter alone. And so I still think we are, people who are actually entered in next year's cap are still going to see a higher chance of actually being selected, especially if you have a US master's degree, irrespective of the potential wage selection rule that we'll talk about in a minute, just because a lot of people are not planning to sponsor. And then also the layoff piece too, right? Like, how can you sponsor when you've had massive layoffs? So.
Yes. So that's a great segue to because of course the fee hasn't been the only change that we're looking at. We also have some wage-based changes in terms of how the system works. Jonathan, would you like to talk us through this part?
Okay, so I'm really going to try to make this like as simple as possible because the government's rationale is not particularly nuanced. But essentially for years and years and years, they've been trying to push this concept of H-1B holders depress U.S. worker wages. Now, for us in the particular industry, we know if you have good acting employers, it's technically impossible for them to actually undercut the U.S. workforce by paying foreign nationals less because of the fact that you have to pay the prevailing wage or the actual wage. We also all know, because there's 4 wage levels, there's some game playing that goes on, and it does have some sort of corollary effect. So like most things within the Trump administration, there's a nugget of rationale between the irrational policies and behavior. And that's really shows its way here. So essentially what's happening, they're saying, we think that the higher wage earners are better for the country. And if we really want to avoid or discourage employers from bringing in foreign nationals at entry-level positions when there's tons of US workers. So here's an idea. Let's weight the lottery. WEIGHT. Let's weight the lottery. And what they're saying is we're going to give you extra lottery tickets based on the wage level for an occupation. So if you are wage level 1, you get 1 lottery ticket. If you're wage level 2, you get 2 lottery tickets. If you're wage level 3, you get 3 lottery tickets. If you're wage level 4, you get 4 lottery tickets. And the idea is the higher the wage level, the greater chance you are of going to be selected in the H-1B lottery. This does not circumvent, nor can it, this cast aside allotment of 20,000 H-1Bs for those that have earned U.S. master degrees or higher from a U.S. institution. Does not affect that. But theoretically, you could have somebody with a U.S. master's degree and wage level 4 that gets 5 lottery tickets.
Yeah.
So it's supposed to weight the higher side of things. Now, the theory is well, this is really going to take away the game playing. This is not going to have people undercutting wage levels. However, it ignores the fact that when the government moved from the Dictionary of Occupational Titles, and I think Linda and Lisa probably are jiving with me on the early 2000s immigration vibe here, and we moved to ONET, we had dramatic shift in the way the Department of Labor views jobs. It was no longer a single occupation that had a single analysis. And by the way, if you want to go into the Wayback Machine and see the Dictionary of Occupational Titles, it is spectacular. This thing is like a massive tome that used to sit on our desks, like this big. There'd be like 1 entry for computer programmer and like 4 entries for worm farmer. I mean, the thing was like absurd. Anyway, so we moved to these occupational classifications. Within these occupational classifications, they give a lot of different job reporting titles. And whilst they feel that this wage level thing is going to change, and it will have an effect, I don't think it's necessarily going to solve for the problem that they think they're solving. So for example, to give some context, if you look at market research analyst on ONET, and you look at marketing manager on ONET, the job reads very similar. And there's a lot of actually crossover reporting titles. But at like, let's just say $100,000 in Des Moines, Iowa, you're going to be a level 1 marketing manager, but you're a level 4 market research analyst. So if you have an attorney that understands the parallels and the way the reporting structures are so that you are not actually gaming the system, but working within the bounds of it, you can theoretically put yourself in a wage level 4 occupation with 4 lottery tickets by choosing a different occupational classification. So the ability for manipulation of the statistics to enhance lottery chances will continue to exist. Again, this is where I think more of a common sense approach to the reality of this situation would bear better fruit for the government's agendas. Specifically, this concept around if you've had layoffs, you cannot hire in on H-1B. So not to pick on my Bay Area friends too much, but if you have a company that's laying off 10,000 senior programmers and wanting to replace them with entry-level people and using the H-1B as a mechanism for doing so under a rule that accepts the reality of the changing labor force, that would not be possible. But under the proposed rule, it might not actually effectuate the amount of applicants that are being submitted. And I think that that is fundamentally the challenges with this proposed regulation. Now, just a word on this for everybody, that because it is a regulatory effort and because we do have like a sort of a accelerated timeframe for notice and comment, I just to kind of, as Linda did such a nice job with the litigation here, my best guess is this will be moved to final rules sometime in January. And it will be put in place well in advance of this year's lottery selection. So practitioners and companies should start thinking about it and planning a little bit around this change.
Yeah. So we've talked about the uncertainty about related to the H-1B program. We've talked about some of the critical changes that we're seeing. This is why a lot of in-house immigration compliance managers are working very closely with their immigration providers, all of you here and our broader industry colleagues, to make sure that they're keeping up to date on the latest news, because literally overnight things are changing. So let's talk a little bit about the overall impact of some of this uncertainty and changes. Obviously, some clients who maybe have a very big budget, they are happy with some of these changes. Some are definitely not, because they're disadvantaged, right? So it's not going to be the same strategy across the board, depending on exactly the corporate culture and what clients want to do with their talent strategy. But let's talk a little bit about what corporations could consider in terms of this uncertain environment. Are there other U.S. visas that they can look at? Is there an opportunity to think about location changes, parking, as it's referred to? Let's talk a little bit about solutions that corporate clients can consider. We'll start with some of the alternative U.S. inbound visa options. Linda, what are some of your clients looking at in terms of alternatives to the H-1B? Do you see any trends for maybe 2 or 3 visa categories that are being considered as an alternative? And then I would love to have Lisa and Jonathan comment on this too.
Sure. Yes, for sure. I think some of our clients are already building their offices in other countries like Mexico and Canada. The TN is a beautiful visa to use to come on in. They're our neighbors, and they still work on some of our same time zones, so it's a viable option. We're also considering O1s. We're looking at our extraordinary abilities for our, if you have a higher degree, master's, PhD, and those, we're building a practice of HSI, our highly skilled individuals, reaching out to them and seeing if there's options for that. And everybody's looking at other options. I've told clients also, think about some of your partner clients that you have for our companies. Think about placing people there on their other offices, right? So because you have, they work for other companies, and that could be a viable option for them too. So we're looking globally. We're thinking globally. It's what you have to do, I think, to manage what's happening in this climate.
Absolutely, yes. And can we double click into the O1 visa? Because I think extraordinary ability sounds very fancy. And I think it could be considered as something that people automatically think they're not eligible for, and so they never even consider it. Can you just give us a high-level idea of what this visa category requires and what type of applicants should consider it?
You have to show, that you've done some publishing, You have to show work and other evidence that you have been, you're an expert in this field. I used to always say the rocket scientist is the what I actually handled a rocket scientist for a company once, and so he got it easily. But it is extraordinary, and I think you have to really glean through your resume and what you've done, be ready to prepare all that. They do take time. I don't think they're quickly can turn it around in 7 days. It's something you got to really talk to them about. Then they need to also figure out, have they done presentations? Have they joined professional organizations? And it's not just a YouTube video you made because you felt like, okay, that was great. Here, let me talk about it. Others have to recognize what you've done as extraordinary. So it takes some work.
Yeah, I also think like, so there's, there's the O1 for a researcher, and then there's extraordinary ability. And I've done O1s for people in the creative space. I've done like marketing professionals who've led major brand campaigns for corporate clients. I've done chefs, artists,
I think that's the beautiful thing. Anybody can be extraordinary.
anyone can be it. Yeah. And so like I've done dancers, and even now we are getting inquiries for TikTokers and YouTubers and things like that. And so if you can get really creative with it, if you've made like one YouTube video and it doesn't have very many hits, you're probably not going to get an O1. But if you are, a major brand on YouTube and have a huge following, then yeah, I think we can make the argument for an O1 for you. So I know a lot of people really focus and think of the O1 and kind of the sciences, math space, engineering type space, especially the OR in particular. But the criteria for artists and other professionals, you can weave your way into doing that, especially for some of the smaller businesses that we deal with. So I think the approval rate on O1s is still decent for non-frivolous O1s right now. I think we're seeing some issues on EB2 and IWs that are self-filed. There's a very big RFE and denial rate on those, but that's on kind of the green card side. But yeah, if you have an experienced practitioner that and you're really creative in kind of the evidence that you're preparing and how you're preparing it, and also who your reference letters are coming from. That's a big component of the O1 also, is that you need to try to get expert opinion or reference letters. If you have good references, I think that's could sometimes help you sail through at the CIS level.
I couldn't agree with you more on that. If the reference letter is like a household name in particular, it tends to have a pretty dramatic impact. But I would caution against that, just in so much as the government does like what we call contemporaneous evidence that existed at the time for a purpose other than an immigration filing. Like the letters can be a little self-serving. One thing I would like caution people against is these pay-for-play publications that are growing in popularity. The government is hip to that.
We're getting a bunch of RFEs on that. Yeah.
If you're paying to have something published, that is not organic published material.
Right.
The great thing about the O is that if you know the list of qualifiers, you can make yourself extraordinary.
Yeah.
And like I love what Lisa was saying, but yeah, you can be an extraordinary grocery bagger if you won the national speed championships for grocery bagging. It could be absolutely anything. I think fundamentally what we have to realize is that when we do analysis of cases where it used to be H-1B was the default, and then everything else was stuff we would talk about if somebody was not selected in the lottery.
Yeah.
Now everything else is the primary objective, and the H-1B is almost becoming the default. And it's a seismic shift in the way that we're analyzing cases.
Yeah.
And further to Linda's point, companies setting up operations outside the United States to facilitate future visa travel is so contradictory to the administration's want to bring manufacturing and operations back to the US. It's almost like that real tangible example of policy that is contradictory into of itself.
Well, and
You
it's
want to
so,
bring
it's so,
manufacturing back. You're
yeah.
limiting visas, so to get the workers they need, they're having to send them overseas. It's really not jiving with what is meant to be the purpose for the direction of corporate growth within the United States, within their own policies.
Well, and
Uh,
it's so interesting you say that, Jonathan, because I mean, this has been going, I mean, I'm in the global immigration space, so I've been kind of looking at trends with companies moving out of the US. And it's been going on for a few years now,
Yeah.
probably since COVID, honestly, where especially in the Bay Area, the prevailing wages are extremely high because the prevailing wages for an H-1B, you can only take, it's essentially just the base salary. However, the wages are determined based on looking at equity and overall comp, yet we can't use equity or stock or vesting or any of that or bonuses as part of when we're filing an H-1B to meet the prevailing wage. And so what I saw during COVID is that people were moving, they were moving to all different places, often cheaper locations, closer to family. And so people said, okay, if you're moving, we're going to start paying you less, which is great because we don't want to necessarily pay you these Bay Area wages. We're going to pay you the wage of, someone in Chicago or Iowa or Florida. And, it's a great way to kind of reduce our overhead. And then what I saw even further is, hey, there's all these other talent hubs popping up in Poland, for example, in Serbia, in the Middle East. And some of these locations, it's just a lot cheaper and easier to do business. Maybe there's some more cumbersome employment laws that, there's not at-will employment like there is in the US, but we're willing to put up with that. And we're willing to put up with some of the corporate tax and restructuring pieces so that we can overall hire a very large core of, say, software engineers that are very well educated
Yeah.
and very high functioning at just a much, much cheaper price point.
yeah,
And it just reduces our bottom line. And so
well,
I've been
even
marketing
these,
for years.
yeah, and sorry, I didn't mean to talk
No,
over
you're
you,
fine.
Lisa, but this, like, we've heard of these concepts of offshoring since the 80s.
Yeah.
Now it's like nearshoring. I mean,
Yeah.
look, notwithstanding challenges in Canada, and we have offices up there, like during the first Trump administration, when they became restrictive, they opened up visas so people could go there and operate
Yeah.
in the same time zone. Like,
Yeah.
I know everybody wants to have a return to office, but let's face it, we're here now having a very prolific discussion over the internet and not sitting
Yeah.
together.
Yeah.
I mean, the world has changed, except we have an
Yeah.
administration that keeps thinking it can be like it was before. And I think that this kind of, Lisa, goes to your point, is on global mobility, a lot of European countries in particular have started to recognize the fact that the death rate is exceeding the birth rate. And on a pure economic basis, just pure macroeconomics, you need to have more people. At a time where you would think we would lean into immigration to help stem that in the future for the United States, we're having this opposite effect to the benefit of these countries that are trying to draw population because of their own dwindling numbers of people.
Yeah.
Yeah.
And
Yeah.
it's
It was
I think the
definitely.
timing is off.
Yeah.
Yeah, I would say also, at the Wearable IDRC conference, it was definitely a trend hearing from our colleagues in Latin America that companies are very much interested in hiring in Mexico, that they're seeing more moves domestically within countries and also within the region, as well, more so than they have in the past as a result of some of this uncertainty. And I know we won't be able to go through the whole alphabet soup, so to speak, on US visas, but I'd love to get a question from the audience related to L1s. So there is this idea of let's just have this foreign worker that we really want to hire working their home country remotely and then for a year. And then can we bring him to the US? Or can we use an employer of record and then bring them over on an L1? Linda, would you like to take a stab at this one?
Sure. Love the L's. They work pretty well. If you have a manager, I would say it's a little bit easier. The L1B, the specialty occupation or specialized knowledge, is it's a hit or miss sometimes, honestly. And even though they say you have to have had some type of experience only 1 year. They really mean 2 to 3 years applying that specialty in their work. That's what I've seen on the ground. The RFPs you get, you have to prove training, you have to prove actual use, you have to prove your company has built that technology, you own it, they've advertised, they've used it, their clients use it. It works, but it takes effort to glean all that information. Sometimes the conversations with the actual people, the L-1B candidates, that's probably some of your best source of information. They're very technology minded, so they're not very verbose, but that's the time that they want to talk about all the great things they've ever done, and all the ways they've used this and all the things they've accomplished using that specialty. So it's a great option. And I tell clients a long time ago, start building it, start training people, emphasize your products so you have something ready, because it's not something you can just turn around in one year. You should have been building it for the last 5 years, 10 years, actually, and to really satisfy the requirements that the USCIS is looking for.
I think you have to be a little bit careful too on the foreign entity piece. So I mean, there has to be that corporate relationship there, corporate employee relationship. Right. So it's much cleaner if you have a foreign subsidiary, branch, or affiliate, and the individual is working in their home country at that location on that foreign payroll. Very clean. In some cases, if you're doing a lot of L1s, or if your company is at a certain revenue level, you can even qualify for an L1 blanket, which is a filing to USCIS that basically shows all of your foreign entities and kind of the relationship they have to the US entity, the petitioning entity. And it's great because it allows for expedited processing at the consulate directly. If someone has a foreign equivalent to a bachelor's degree in the L1.
Lisa, just out of curiosity, I mean, we're seeing it, but like we're seeing blankets, which used to be substantially easier on adjudication trends than internal filings, are getting a lot more kickback these days, particularly in India. Has that changed your strategy a little bit?
I mean, I have some large clients that have the blanket, and I've had a couple clients that have fully restructured in the past year, and we've gotten our blankets approved without issue. However, I have a lot of smaller clients that don't have blankets. And I mean, while I think the RFE rate on Ls and L1Bs in particular, even during parts of the Obama and Biden administration, were actually very high. So I don't think I'm seeing like a difference in RFE rates on those cases at USCIS. And if oftentimes you'll get an RFE that's, I call it a kitchen sink RFE, where they just basically are like, we didn't read anything, resubmit everything, and kind of tweak it a little bit. And I've been actually able to get those approved. Shockingly, through premium processing, things have been sailing. Maybe I shouldn't say this.
I think they've been okay internally. It's just and just for the audience, and these are moving trends and everything like that. There was some heavy issues with blanket filings out of Brazil all of a sudden, where everything was getting denied.
Yes.
That's pulled back.
That was a bit of a rogue.
Yeah.
There was a couple, I heard Sao Paulo, there was a couple.
Sao Paulo was
new. It might have been, I'm not going to say rogue, because maybe it's a new officer training issue, right? The consulates, the foreign service, a lot of people have left, rejoined the foreign service. And so people, with the foreign service, people rotate at the consulates, and often new foreign service members are, placed at different consulates. So maybe it's a training issue. I'm not going to say.
I heard the Brazil thing was and I'm not trying to like be fake news, but I heard the Brazil thing was stemming from some political issues that were arising out of litigation against the former leader that the president in particular. Like, I do think the scenario on training is what we saw coming out of India. Yes. There was some issues. There was some serious issues there for a hot minute.
Yeah. But I feel like in Chennai in particular, every couple of years, we have mass denials of blankets. And then AILA complains, or we have meetings, and then it gets resolved for a little bit. and then we have another period of where it's going okay, and then it's mass denial. So I feel like that's been going on for, I don't know, maybe 10 to 15 years of just periods of back and forth. I mean, India
Yeah.
is always challenging, I think, in general. If you have someone coming out of India, English language knowledge is really key in terms of making sure that they're prepared at the interview and they really understand
Well,
what is in the petition.
that's the most important one, because you know they're not looking at documentation anymore. A blanket's a little bit
Right.
of an exception because it was a bit, but they're just going based on questions. If you
Yeah.
don't know the reason why you're coming, it's not going to be approved. It's like,
Right.
Yeah, and also like proving your like when with my L1Bs always, I mean L1A, if you can't speak English and you're coming to be a manager in the US, it's usually a no-go. Like, right? It's very difficult to come back from that. I mean, we've, done things like where we, some of our companies are offering language training in the US. I think that's really helpful
Mm.
if the company has language training to add that in and have them talk about that. But L1Bs in particular, showing why they need to be based in the US market, showing the value, often in terms of like revenue, product development, go-to-market strategy, all of those things are super critical to have the person communicate at the interview. And then also, if you're doing a CIS filing, to really lay that out in layman's terms in the filing.
Yeah.
Yeah. And we do have another question related to sort of looking outside of the US as a solution. The UK often comes up as a country where it's a good idea to place foreign talent. Linda, can you share a little bit about the UK? Is it the end all solution? Are fees very low in the UK? What do the corporate requirements look like? Just in the last few minutes that we have before we wrap up.
So I can't really speak too much on the UK, except I know they're great. I love Downton Abbey, and they speak English, so it's great for candidates to go there. I'm not sure if the process is involved with setting up a company there. I don't have too many clients that do that. So maybe Jonathan or Lisa.
I can chime in on that.
Yeah.
So I mean the UK, the benefit of the UK, it's very interesting. In the UK, they had, but pre-Brexit, their sponsor license and certificate of sponsorship and their tier 2 visa, it was actually very difficult to get a visa, to get a work permit and a visa to the UK, because people were limited based on quotas, like that they had to apply for in advance, and you were given a certain quota within the year, and then when it was exhausted, it was exhausted. And so the funny thing about Brexit is that they redid their immigration system, and it actually, with their skilled worker process, you can essentially get a skilled worker whenever you want now. You can request a certificate of sponsorship very quickly if you have a valid sponsor license and have an entity set up there. You cannot use an EOR model in the UK for sponsoring foreign workers. So that's a hard no. But the sponsor license, if you are, on the company house directory, it's a fairly easy process to do. But the thing in the UK, you can get a visa very quickly for someone, but the fees are astronomical, and they continue to grow. And so I think basically for the past 2 to 3 years in April, they have increased the skilled worker fees. There are, certificate of sponsorship fees that need to be paid. There are skilled worker fees. There's an NHS contribution if you're there. Anything
there's also a registration fee for the company as well, which is like,
yeah, it's for the sponsor license. That's still reasonable. So and what I find with UK assignments is that, my legal fees are quite low, but the sticker shock really comes when the client gets the the bill from the government. And I give them all the fees up front, right? Like it's all like, here's what it costs, here's what it is. And then they, get a $25,000 to $30,000 USD fee, it's equivalent to a USD fee. And they're like, for a family of 3, and they're like, what is this? Can you reduce it? And I'm like, no, this isn't my fee. This is the government fee to come here for that's like a 3-year assignment. It's not even a 5-year assignment. And so I think the UK, while it's great, if you have an entity there, they speak English, there's often a lot of familiarity. If you're on the East Coast, the time difference isn't that different, it isn't that bad.
Yeah.
The sticker shock of the government fees is still extremely high.
I know
There's-
we're out of time, but I would like to say one irony of the entire UK situation is that Brexit was created based on an anti-immigration platform, and as a result of
wow.
it, they've had more immigration than ever.
Well, they're trying to kind of, they're going back to the right again, I would say.
Yeah,
Or
no, I know, but the
they're trying to reverse
irony,
course a bit.
the irony of the way that all played out is
It's-
palatable. So,
Yeah.
Unfortunately, we're out of time. I know that we could all be here for another couple of hours minimum to talk about all of these very dynamic topics. I think as a summary, I would like to say that it is probably more critical than ever for corporate clients to partner very closely with the experienced immigration lawyers and their teams. Shout out to all of the hardworking paralegals out there.
Yes.
Yep.
Because things are never dull in the immigration compliance space. I think we're all happy to be here, though. I think if there's something to be said about this community is that we're extremely resilient and we have solutions. It's, no matter what happens, there will always be a path forward for businesses to have a very strong talent strategy in place and many plan Bs and Cs and Ds as well. So I want to thank you all so much for being here with us today. Hopefully this content resonates with our audience. And if it does, well, maybe we'll have to do a part 2 as well. I wish you all a wonderful day ahead.